All right, let's get straight into it. Ever felt confused, maybe even scared, about what really happens if you get arrested in Texas? Maybe you're worried about a past mistake showing up on a job application or, someone tangled up in the system right now trying to figure out what's next.
Yeah, there's this common idea out there, right? That if a case gets dismissed, poof, it just disappears, gone forever.
Exactly. But is that really true? What rights do you actually have? What's this whole process from arrest to maybe a trial even look like? How does it impact your future, your job, your housing, even seeing your kids?
Stick with us. We're going to break it all down step by step. By the end of this, you'll know exactly how this journey unfolds in Texas.
Okay, let's start at the very beginning, the arrest. An officer can't just decide to arrest someone for no reason, can they? There's got to be something more.
Absolutely not. In Texas, like everywhere in the U.S., an officer needs what's called probable cause. It's a legal standard.
Probable cause. What does that actually mean in plain English?
It means they need solid facts or circumstances, enough to make a reasonable person believe that a crime was committed and that the person they want to arrest is the one who did it.
So not just a guess or a bad feeling.
No. It has to be based on something concrete. Maybe they investigated beforehand, gathered evidence, talked to witnesses, or sometimes they see the crime happening right there in front of them, like witnessing a theft or an assault, something like that.
Okay, so there's a legal basis. It's not random.
Right. It's actually written down. Article 15.22 of the Texas Code of Criminal Procedure. It basically says once they have that probable cause, they can make the arrest. It's a protection, really. Stops folks from being grabbed off the street for nothing.
Got it. So the arrest happens. What's the very next thing? Straight to a judge?
Not quite yet. First comes booking. This is where you're officially entered into the system.
Booking. Like fingerprints and that picture, the mugshot.
Exactly. Fingerprints, photo, they take down your personal info, what you're being arrested for. It all goes into the official record. It's administrative, but man, is it important.
Now, this is where it gets really serious for folks listening, right? Because that record, it starts right then.
That's the key takeaway. The moment you are booked, that criminal record begins. And listen, this is huge. Even if the charges get dropped later, even if you're found not guilty, even if the case is completely dismissed, that arrest, that booking, it's still there.
Wow. So for that young mom trying to get a better job, or maybe someone trying to get into nursing school or just rent a decent apartment, that record from the booking can pop up.
It can. It absolutely can create hurdles down the road. It's like a shadow that can follow you. That's why understanding this first step is so critical. It stays with you unless you take action later if you're eligible.
Okay, so after booking, then what? You mentioned a judge earlier.
Right. The next mandatory step is called magistration. And this isn't optional, it has to happen. Texas law, specifically Article 15.16 of the Code of Criminal Procedure, says you have to be taken before a magistrate judge within 48 hours of your arrest. 48 hours.
2 days. Okay. And what's the point of seeing the magistrate? What happens there?
This is all about your rights. The judge is there to formally tell you what you're charged with and remind you of your constitutional rights.
The right to remain silent.
Yep. That one. The right to have an attorney. If you can't afford one, the judge will explain how one can be appointed for you. And importantly, the right to what's called an examining trial, especially in felony cases. It's like a mini hearing early on to see if there's enough probable cause to keep the case going.
Okay, rights are covered.
Yeah.
What else happens at magistration? I hear about bail.
Yes, bail is a big part of it. The judge makes the initial decision about bail right there. They decide if you can be released while the case is pending, and so, under what conditions or how much money, the bond amount.
What goes into that decision? How do they decide the amount, or if you even get bail?
They look at a few things. The seriousness of the charge, obviously. Your history, if you have one. Your ties to the community, like job, family. Do they think you're a risk of running off or maybe a danger to others?
And I know there's been talk about changes to bail in Texas recently. How does that play in?
Yeah, that's a big deal, especially with reforms set for 2025. It's kind of shifting the landscape right at this early stage. Judges might have more power now under laws like SB 9 and SJR 5 to deny bail completely in certain serious felony cases. And prosecutors can actually challenge a judge's bail decision they don't agree with.
So it's getting potentially tougher to get out on bail right away for some charges?
It could be, yeah. It puts more focus on that initial hearing, that decision whether you wait at home or wait in jail. I mean, that impacts everything. Your job, your family, your ability to help your lawyer prepare your defense. It's huge.
Okay, so you've been arrested, booked, seen the magistrate. What's next in line for formal charges?
Right. The next step is the state formally bringing charges against you. How they do it depends on whether it's a felony or a misdemeanor.
What's the difference there?
Okay, so felonies are the more serious crimes, potentially punishable by prison time. For those, the case usually goes to a grand jury.
A grand jury? Like regular people?
Yep, a group of citizens. They meet in secret, hear evidence only from the prosecutor, and decide if there's enough evidence to formally charge you. If at least 9 out of the 12 agree, they issue what's called an indictment or a true bill.
So the grand jury acts like a filter for serious cases.
Kinda, yeah. It's a check to make sure the state has a real case before dragging someone through a full felony trial.
And what about misdemeanors? The less serious stuff.
Simpler process. For misdemeanors, things usually handled with fines, probation, maybe some county jail time. The prosecutor just files a document directly with the court. It's called an information. It's basically the formal written accusation.
So, indictment for felonies, information for misdemeanors. But either way, once that paper is filed, it's official. You're being prosecuted.
That's exactly right. The game is on, legally speaking. The state is officially moving forward.
Okay, charges filed. Then comes arraignment, right? What's that about?
Arraignment is your next required court date after the charges are official. It's where you formally answer to those charges in front of the judge.
How soon does that happen?
For felonies, usually it has to be at least 2 full days after you've officially received a copy of the indictment, unless you agree to do it sooner.
And what do you actually do at the arraignment?
This is where you enter your plea. You tell the court whether you plead guilty, not guilty, or nolo contender, which means no contest.
No contest, meaning you're not fighting it, but not admitting guilt either.
Pretty much. You're letting the court sentence you without admitting you did it. The judge might also review your bail again, and if you still don't have a lawyer, this is another point where the court can appoint one for you.
So arraignment is kind of the formal kickoff in court.
You could say that, yeah.
Yeah.
It sets the stage for what comes next.
Which is the pretrial phase. Sounds like a lot happens here before any actual trial.
Oh, absolutely. The pretrial phase can last a while.
Yeah.
This is where both sides, prosecution and defense, really dig in and prepare. It's not just waiting around.
What kind of things are happening?
Lots of legal maneuvering. Lawyers file motions basically asking the judge to rule on things, like maybe trying to get certain evidence thrown out, arguing it was obtained illegally, or maybe arguing about what evidence is even allowed in court. A huge part of this is discovery. Remember we talked about fairness? Well, Article 39.14 in Texas law says prosecutors have to share their evidence with the defense. Police reports, witness statements, lab results, all that stuff.
They have to show their hand.
Pretty much, yeah. Early and fully.
Right.
It's so the defense knows what they're up against and can prepare properly. This is super important, for someone trying to keep their professional license, like a truck driver or a barber, they need to know exactly what evidence the state has.
And you mentioned Houston courts have made some changes here.
Yeah, down in Houston, they've put in some reforms specifically around this pretrial discovery, trying to speed things up, reduce backlogs, but also, importantly, trying to prevent unfair prosecutions by making sure that evidence, especially evidence that might help the defendant, gets turned over promptly. It's about efficiency, but also justice.
Makes sense. And is this also when plea bargains happen? I hear most cases don't actually go to trial.
Exactly. This pre-trial period is prime time for plea negotiations.
What is a plea bargain exactly?
It's a deal. The defendant agrees to plead guilty, maybe to a lesser charge or for a specific sentence recommendation, and in return, the prosecutor gives something up, maybe drops other charges or agrees to that later sentence.
Why are they so common?
Well, for the state, it guarantees a conviction, saves court time and money, avoids the risk of losing at trial. For the defendant, it gives certainty. You know the outcome, avoid potentially worse penalties if you lose at trial. It can be a way to resolve things faster.
Especially if someone's just trying to move forward, right?
Yeah.
Like someone getting out, trying to rebuild, or a dad fighting for visitation. Sometimes certainty is key.
It can be. It's a complex decision, always, but it resolves the vast majority of cases.
But what if no deal is reached? Then it's time for a trial.
Then it's trial time. If you can't agree on a plea, you exercise your right to have the state prove its case.
How does a trial even start?
It starts with picking the jury. That process is called voir dire. Both the prosecutor and the defense lawyer get to ask questions to potential jurors.
To weed out biased people.
Essentially, yes. The goal is to seat a jury that can be fair and impartial, listen to the evidence, and make a decision based only on that evidence and the law.
Okay, jury picked. Then what?
Then the trial really begins. You have opening statements. Each side tells the jury what they plan to prove. Then comes the evidence phase. The prosecution presents its case first, calling witnesses, showing exhibits. The defense gets to cross-examine those witnesses, challenge their story.
Then the defense gets its turn.
Right. The defense can present its own witnesses and evidence, and the prosecution gets to cross-examine them. After all the evidence is in, you have closing arguments. Each side summarizes everything, makes their final pitch to the jury, arguing why the jury should see it their way.
And then the jury decides.
Then the jury goes back to deliberate in private. They discuss the evidence, the law the judge gave them, and they have to reach a unanimous decision, guilty or not guilty.
What if they can't agree?
If they're truly deadlocked and cannot agree, the judge might declare a mistrial. Then the prosecution has to decide whether to try the case again with a new jury.
Okay, let's say the jury reaches a verdict. Guilty or not guilty. What happens then?
If the verdict is not guilty, you're acquitted. You're free to go on that charge. Case closed, legally speaking.
And if it's guilty?
If the verdict is guilty, the case moves to the sentencing phase. Sometimes this happens right away, sometimes later. Especially in felony cases, there might be a whole separate hearing for sentencing. Often, a probation officer prepares a detailed report for the judge. It's called a pre-sentence investigation report, or PSI.
What's in that report?
It covers your background, criminal history, family, job situation, maybe victim statements, anything the judge might need to decide on the right punishment, whether that's probation, jail time, prison time, fines, or some combination. It helps tailor the sentence.
So even after the verdict, it's not necessarily over immediately.
Right. And even after sentencing, you still have rights. You generally have the right to appeal the conviction or the sentence to a higher court, arguing that legal mistakes were made during the trial.
And importantly, going back to that record we talked about at the beginning, what happens to it after the case ends?
That depends heavily on how it ends. If you're found not guilty or the case was dismissed outright, you might be eligible later to get that arrest record expunged.
Expunged, meaning wiped clean.
Effectively, yes. Expunction means the record is destroyed or erased, like it never happened. It's the best outcome for clearing your name. In other situations, maybe if you successfully completed something like deferred adjudication probation, you might be eligible to have the record sealed.
Sealed versus expunged. What's the difference for someone trying to get a job or housing?
Sealing, or getting an order of non-disclosure, means the record still exists, but it's hidden from the general public. Most employers, landlords, schools won't see it on a background check. Law enforcement and certain agencies can still access it, though.
Okay, so sealing hides it, expunging destroys it.
That's a good way to put it. Expunction is better, offers a true clean slate. Sealing is still very helpful, makes it much harder for most people to see the record. Knowing if you're eligible for either one, that's crucial knowledge for moving forward.
Absolutely. Understanding that pathway from arrest, through all the court dates, the potential trial, and then what happens after. It's a lot, but knowing the steps is power.
It really is, and it brings us back to that key question for everyone listening. Think about it. Even if a case ends well dismissed, not guilty, record sealed, that journey through the system, that initial arrest record, it leaves a mark. It creates stress, costs money, impacts your family. So what does that mean for you or someone you care about? Maybe someone denied a job, struggling to find housing, maybe an immigrant worried about their status, or just someone trying to leave the past behind. How does knowing this process empower you to fight back against those lingering effects, to take control, and maybe finally clear your record?
That's the challenge and the opportunity. Don't stay stuck. Get informed, understand your rights, and know the path forward. If you need help figuring out how to deal with a Texas criminal record, there are steps you can take.
That's right. Take that first step. Visit legal-gangsta.com.
That's legal-gangsta.com.
If you're in Harris County, go to legal-gangsta.com right now and get your free 10-step Erase Your Criminal Record guide. Start that journey to freedom and a clean slate today.
Don't let the past define your future. Take action. Visit legal-gangsta.com.